are listening to The Bail Post. Welcome to episode 38 of The Bail Post. In this episode, we will be talking about the important changes to the law that were made by the Florida legislature in the last legislative session. And there were some important bills that passed. And today's guest is Shawn Foster, who's been with us before. Shawn, thank you so much for joining us.
Happy to be here again with you.
Well, since you've been on our podcast the last time, I think last month, I was just looking up, searching for other criminal justice podcasts, and I found this list of 60 best criminal justice podcasts. And I was like, wouldn't it be nice if the Bail Post was on there sometime in the future? And I looked down and we were number 8, and here we are a month later and we're number 6. And so I was like, it's only because of your willingness and other people's willingness to come and talk bail, but I think it's attributable to you and our other guests. And so I just say thank you for being a participant and helping us to achieve that.
Happy to be here. And again, we really enjoyed it last time. So when you called again and asked us to participate, we were looking forward to it.
Well, good. We were talking beforehand. For some reason, I just had my days mixed up. I thought today was Wednesday all day. And so you're waiting for me. And I'm like, well, it's tomorrow. No, it's today. But if you were going to describe the legislative session this time in Florida from a bail perspective, how would you describe it?
I would say 2 words. I would say Ron DeSantis.
Yeah, that's one of the things that somebody asked me about. Well, when the governor proposes a bill that you may not support, what do you do? And I'm like, it's too late when you're in session.
Smile and hold on is about what I'll say it too, it could be several answers that if it was a governor that was different than the party that's not in the legislature, that can make it different. But as you know, I'm going to tell you, we have the most powerful governor that I have ever seen in Florida. I've been doing this now for 25 years. I've seen Jeb Bush, who had truly a great hand on the legislature when it came to being a statesman. But I've never seen anybody as powerful. And as I've obviously seen him, he's running for president and everything else. But he has a grip on this legislature. He has a grip on this state. He has a grip on the bail industry.
The major bill that was called the governor's bill was House Bill 1627. And, what I've heard about it, it's a statewide bail schedule, and there's other parts to it too. But when that came to the legislature, I think it was filed by a powerful Republican in the House who, from my research, he's supposed to be the next speaker of the House. So
we have one more speaker before him, but he's in line. And we are very fortunate. We've had a good relationship with Representative Sam Garrison. He's the speaker designate. And, so when he took on the bill, we were very, very happy on that part. But, we quite understood very well that language was not coming from Representative Garrison. That language was coming from the governor's office. And so when you want to amend something, generally in that process, I'm not telling you anything you don't already know, you're able to work that kind of language out with the state rep or the state senator. Mm-hmm. In this situation, it was you'll have to speak to the governor's office.
Well, I was kind of thinking about that once. What was the problem, do you think, that the governor was trying to address through this bill?
There was 2 big problems. One, he was seeing just statewide an issue of folks getting out before the first appearance, on pretrial programs. And he was hearing from several folks. One, we have got a phenomenal relationship with our chief financial officer now, Jimmy Petronis. And we can talk about it. We'll talk about another bill that he filed on us. And so where this conversation kind of culminated from, this is the kind of relationship is phenomenal. And when I tell our bail agents, this is how you become successful. I got a call from the chief financial officer. He said, Shawn, I'm going to be with the governor on Monday in a plane. What do I need to tell him about bail? Mm-hmm. And this conversation started. The governor was already quite aware about what was happening in another area that was just so exaggerated on what should be done. They were taking so many people in South Florida, out of the first appearance groups and putting them into pretrial programs. It was outlandish. We shared this with the chief financial officer, who shared it with the governor. And to be honest with you, we did not have our hands in this bill in the sense of, saying we wanted the
Mhm.
Supreme Court to do it. I don't think it was actually. We have an unbelievably conservative Supreme Court. I don't see that changing for as long as I'm involved in politics, and probably my kids. So we're talking at least 30 years if it changes. But it's probably not a bad route to go. So we never had a statewide bail bond schedule. We're allowing the Supreme Court to do it, and that's where it's going to start.
When I was researching this, I found something about, a joint project between the 11th
Uh,
Circuit, which is Miami-Dade County, and they
yeah,
were planning to enter into kind of an experimental project with Arnold Ventures. And then I saw that after this bill was signed, they stopped that. So I'm
they,
assuming that that was one of the things the governor was seeking to address.
so it is. So that was called an interlocal agreement. You took now. Remember, when you do an interlocal agreement, you have to have the sheriff, the public defender, state prosecutor, the county commissioners, and the sheriff all agreed. I'm doing my fingers on, but all these guys all agreed that this was the best way to handle it. So it wasn't just like, you have a liberal, public defender that says, I think we got a good idea to keep people out of jail. You had a sheriff.
Mhm.
Everybody agreed. So that was pretty monumental to have that type of interlocal agreement for pretrial programs. We've seen other interlocal agreements in Pinellas and other counties, but none as severe, and I'm going to say as liberal as we had seen in Miami. And so you took that with the type of things that the governor has been talking about being harder on crime. And as you can see very quickly, this did not match what he thought was a good policy for the state of Florida.
Well, when you look at like the write up, or what they described their program was going to be, I mean, it looked like exactly very similar to what the governor was talking about. They were saying, "Oh, well, this is actually going to be good." I mean, it's more of the things that we see where releasing more criminals is going to reduce crime, which it doesn't make
Right.
sense. It didn't make common sense. And then, in reality, that's the common sense. Releasing more criminals causes more crime, and so we've been dealing with this risk assessment in Texas, and we have someone in the legislature who's adamantly opposed to it as well, and so they haven't gotten a foothold in Texas, but I think they came very close several legislative sessions ago. Well, as I was looking at 1627, or House Bill 1627, there were several parts to it, but let's talk about what the law was before 1627. Did y'all have bail schedules before the bill, or county bail schedules, or did y'all just, I mean, what was the situation?
A statewide bond schedule has really been a discussion with the association, Florida Bail Agents Association, since I became their lobbyist almost 10 years ago now. There were some that liked it, some that did not. Some were probably worried, so let me start first. Let me tell you where it is. Currently, each chief judge in each circuit creates their own bond schedule, right?
So that's similar. That's similar to California, which does it on a county by county basis.
Correct. So you're right. So I have some circuits that have two, some that have six, some of them one. We have 22. I have 67 counties, 22 circuits, 22 chief judges. That's 22 different bond schedules. I'm not gonna tell you they were close, and they were close in some areas, but
Sure.
South Florida, Palm Beach, again, liberal counties, very Democrat dominant. We're obviously had much more lenient bond schedules. You're not surprised, to hear that.
Sure.
So that's why you would see some that are like, yeah, we really need it, and then others are like, I've got a great relationship, with the chief judge. I don't want to screw this up, with all due respect.
Well,
But
talk to me about this though. What was the purpose of the bail schedule? Because when I was reading through this, it looks like it was to obtain release only up until the initial appearance. And
correct. So what was happening, and so you were having, so this bond schedule was allowing folks to get out without even seeing a judge at first appearance. In the state of Florida, you have first appearance within 24 hours, and it's usually, very early in the morning, but with 24 hours, you've been in jail, you were able to see a judge. So these folks so here's what they were saying. They were going up and they were like, hey, here's what it says for this. So you literally had an officer, with a sheriff's office, a deputy saying, this is what it is. It can be between $600 and $800. He's only had 2 arrests, so we're going to give it 6. So he had to do it. So folks were able, number one, to bond before the first appearance, or, and this is the big or, they were going into pre-trial. So let me give you this explanation. I'm in jail. I've got a deputy that comes up to me and says, now listen, I know it's 10 o'clock. You're not going to get to see the judge until 7 o'clock in the morning. So if you want to get out, you either come up with this, or we've got this great pretrial
Yeah.
program that we can put you in. You don't have to put anything down. You can get out of jail just by signing this. Now, by just signing this, agreed to taking urine tests that I had to pay for, by wearing an ankle bracelet that I had to pay for, that if I didn't do these things, that I would, be back in as a violation of probation and have a higher bottom. None of that, again, that's all that small, like 8 point on the bottom, writing. And some of them didn't even have any. So in other words, at the end of the day, they were getting out of having to pay a $350, $500 bond, but they were paying more money
Yeah.
in these trial expenses.
Well, when I was reviewing the bill, we've talked about statewide pretrial bond schedules in other states, and there's always been a question about the constitutionality of them. And so when I heard about this, that one of the questions that I was raised and I talked about with other attorneys is, well, what about whether this is constitutional? And I thought that this bill has several points that addresses that constitutionality requirement. The first one is, it's not the legislature doing it, it's the Supreme Court doing it.
Correct.
And then the second thing that I think gives it better protection just as well is that the circuits have the ability to petition or apply to the Supreme Court to apply a different bail schedule in their circuit.
Correct. Now, the link of the constitutionality, which I wasn't too worried about, is even though the chief judge has the unilateral capability to send it, they still have to send it up to the Supreme Court. This is, it was current. And in a sense, they would write back and approve it. Now, they never, ever in an instance could I ever tell you that they told a chief judge to lower those bail amounts, but the process still had it under the purview of the Supreme Court. So I will tell you this. This was a highly debated bill within our association. There were some that were quite afraid of the process, and I get it. We're putting the hands of a statewide bond schedule into a few folks, the Supreme Court. Like I just told you in the beginning of the show, though, we have one of the most conservative Supreme Courts in the nation. They have been appointed by either Governor Ron DeSantis and Rick Scott, all my members. This is the most conservative group that that has ever been there. And the only other time we had some folks that were there were Governor Charlie Crist, and of course, but his appointments were done when he was Republican, and the last ones before that. But all those are already gone. So my story, going to tell you, I understood and knew that no matter what, we were going to have a very conservative court. I wasn't worried about any of the bail amounts coming down. I was telling everybody, you're going to see these bail amounts go up. I mean, you're going to see, and I think that's, again, I think that's a good thing in some instances because more people are going to want, they're going to be in court. But the biggest issue is that it's going to decrease pretrial release. I mean, absolutely. These folks are going to not be able to get on the pretrial release until they get their first appearances. And it actually changed some items where folks could even get the out before the first appearance, like a DUI, BUI, and some other charges were added to it. We have a long list of charges of folks who aren't even to get out prior to the first appearance.
When they go to the first appearance and they don't bond out, does the bail schedule no longer apply? Is it then just the discretion of the judge, or is he still he refers to the bail schedule to set bail?
So that's a great question. I have sat in multiple first appearances. I first want to get this myth out that people are sitting in jail with these type of situations, that people are just, sitting in jails because they couldn't make bail. When I am there, and I have noticed the two things that I hear over and over, my friend, are, sir, I'm sorry, I can't give you a bond. You had a failure to appear. You have to go before Chief you have to go before Judge so-and-so in Hillsborough County because you got arrested in Pasco. And the other one is violation of probation. So even though they're still going to first appearance, they can't get it. So at that point, and the reason I mentioned that, those folks who aren't able to get it, the rest say, and the judge is literally looking at the bond schedule, even though you're right, they can go within or without it. They can go lower, those limits. So it does give them those, and I very rarely see them go outside of it. But I do see them go when they do it. It's, let's say that the bottom was like 600, they did 500. It wasn't like they did $100. In the
Right.
areas, again, I'm from Pasco, more conservative area, but I understand down in Miami and Broward, Palm Beach, that was not happening. They were going down to ridiculous amounts and RRs.
Well, since this went through the legislative process, I'm hoping that y'all had a lot of debate about what was going on in Miami-Dade County, and there were people defending it because as a result of COVID, we have a lot of data now, and we have a lot of
Right.
research that's coming out that's really not good for these people. And you're starting to see stories talking about why would we be enacting policies in our inner cities that's really causing crime to increase? Why are we doing things that now is causing stores to have $25,000 a day in shoplifting,
Right.
causing malls where nobody will go there because they don't feel safe, or employees don't want to go to work in malls because they don't feel safe? And so why are we on this death spiral in our urban cities? And so I'm having a hard time wrapping my head about what is the justification, what is the defense of these policies. But
Right.
was any of that attempted during this legislative session?
It didn't have to be, and I only kind of stopped just to tell you it's really because when people knew that this was the governor's bill. First of all, the Republican Party in the House and the Senate, we're in the majority on both. But no, it had very, very little discussion on that. It sailed through the legislature, got to the governor, and the governor signed it. The only two conditions that I didn't tell you about previously, but I did want to say is if a chief, now it'll be set. If a chief judge wants to have a lower amount,
Mhm.
he can petition the court,
Yes.
by the way. If he wants a higher amount, just like they could do before, they can also set. So whatever the Supreme Court sets, they can do higher amounts if they choose.
You mentioned that this was a heated issue, or there was a heated debate among the bail industry on this issue. And we have that in Texas where we'll have a bill that is filed by an ally. We may not agree with every bit of it, but they're an ally, and it's very difficult to take them on toe to toe during the session without
Right.
you wouldn't do that because you're gonna upset your ally. And so I just want to highlight, it seems like when your governor, who is, this is I would say a pro bail bill that we just
Right.
don't we have difference of opinion on how to implement it.
Right.
The time to talk to him about changing it is before it's filed, not after it's filed.
Uh, that was the discussion, and there was some folks that were trying to actually stop the bill from passing and moving forward. It was a very huge divide. It was happening during our conference when we were in Tallahassee during session. I told them I thought that would be the worst thing that you could do. The governor is giving you a bill without your name behind it. We're talking about a conservative governor, a conservative court. So here was their issue, my friend. They were saying, how can we trust the next
I know.
Supreme
I
Court?
know.
I
I
get
think
it.
it's hard for bondsmen to trust. I fully get that. I understand it.
But here's what I told everybody: you all will be dead when that Supreme Court has converted to a liberal court. We all will be dead.
Well, and what I would say is I understand what you're saying, but you can't stop this bill. You can't change this bill. All you can do is upset one or more of the people carrying it, or the one whose bill it belongs to. And they will remember that. It's like, I tell bondsmen, don't punch your sheriff in the nose because you're mad
No.
at him. Even if it's, not really technically punching him in the nose, but confronting him in front of a group of people is the same thing. He will remember that. And that's really, once you get to this stage with the governor's bill, it's passing. It's just whether they're going to remember you were a team player or not.
You talked about in the beginning is, let's remember the gentleman that is sponsoring the bill is going to be a future Speaker of the House.
Yes.
But not only did you have, a governor who just got reelected that could be president in 2 years, could not, but he could be around for the next 4 years. We've got a gentleman who's going to be around for 4 years and more years than the last two. He's going to be Speaker of the House. That was my advice. That was the direction as the association took. There may have been some individual members and others that felt otherwise. The Florida Bail Agents Association took a vote and stayed committed to supporting this bill.
We do that in Texas. If we are concerned about a division in our association, we will call a meeting of our whole legislative committee, and then we'll set out all the positions, and then we'll make a recommendation to them, and we'll have them vote, so that
Right.
we will. I mean, it's almost like you want the cover that it wasn't just 2 or 3 people making the decision on the bill and y'all were wrong, which is what we're told sometimes. But I think that's always smart when you are getting other people to buy into your position, and so then you've got the support. We all agree this is what we did. You may not agree with it, but we took a vote. Come on, you're a member of the association. You were in the minority, but you're still a member. Come on, support what we agreed to as an association. And I had somebody tell me this last legislative session, well, Ken, if you would have argued my position, that position would have won. And I'm like, no, I'm not that powerful. I just
Right.
say, I listen to other people and then I vote along with the people I agree with. That's not what's going to happen. So,
It got heated to the point where I had an individual stand up in the middle of the meeting and say, I'm going to kill this bill. And I said, well, it's very unfortunate that you would go against your entire association because of that.
well, and I would say if you have the ability to kill this bill, you will be the next governor.
Right. Exactly. So,
Well,
and I
and
said,
look, I know it's stressful. These things, when we get in session, it's just mind blowing. I had a bondsman call me one time and literally told me, Ken, if you can't stop this bill, I'm going to commit suicide.
oh my Lord.
And I'm like, what did you just say to me?
Right.
And I said, okay, first of all, I'm going to start calling you every couple of weeks because I'm worried about you.
Right.
And I said, and you need to calm down, and you need to take a step back and just get out of the bail business and deal with family for a while, because you're too all consumed. And I said, now I'm going to add to my long list of things to do that I'm checking on you every week or so,
Yeah.
because we're going to defeat this bill. And I think we did, but now I'm worried about you. And this is not, because we're a family, and for you to tell me that it was terrible and I can't believe you did it, but now I'm going to check on you. And so it all worked out, but I mean, it's just crazy.
You just highlighted, though, is I think sometimes we overshadow, looking at policy and other discussions. But, when the legislature and it passes a bill and the governor signs it has some major implications. I've seen bills passed to put people's jobs and put them out of business. And I don't know what the certain situation is, but generally when people get that upset, it's
Yeah.
impacting their back pocket, their wallet, I always say, and it's very unfortunate. But the legislature, hey, if you recall, Ronald Reagan once said, the scariest words I've ever heard were, trust me, I'm from the government and I'm here to help. Right.
Absolutely. Absolutely. Well, I noticed there's some other parts of the bill that I want to talk about. So there was a long list of offenses where you're not eligible for um, release
Right.
pursuant to the bail schedule. You had to go to the initial appearance. But, a couple things that, all the bad things, all the bad violent crimes, but violent offenses, but also the last one was failure to appear for required court proceeding. You're no longer eligible for a release pursuant to the uniform bail schedule.
That's already been in there. I think that was just a reiteration. Failure to appear, violation of probation, have always been in there. And that's but that's the part you remember. You mentioned those little groups down in Miami. So when they do all these things, right, they're like, oh, how do I say, 17% of these folks couldn't even get bail. No, actually, it was actually 15% because, they had a failure to appear in violation of probation. They weren't even available to have it. So I just, I reiterate that every single time, those few words right
Well,
there.
we even did a podcast on why people languish in jail, and it's not poverty. The number one reason people languish in jail, and it's from a study, is criminal history.
Right.
Your criminal history will determine the length of time that you stay in jail pre-trial, especially today. I mean, there's no first-time offenders being held in jail. I mean, we're talking, and if you're there, it's because you have a criminal history. And once you have a criminal history, you're not being held because you're poor. You're being held because of your criminal history. I don't care what.
Correct. Right.
Now, there was another portion of the bill that I read where it's talking about complying with non-monetary conditions like maintain employment. Was that always part of the statute and we just moved it to a new location?
Yes, sir.
All right,
Yep.
cool. The other part of the bill that I thought was very interesting was a requirement for pretrial detention if you meet certain requirements. And so the bill required the DA to file a motion to detain, so like a capital offense, and that if the certain requirements are met, the statute also required the court to grant the motion for detention. And that seemed like a substantial change as well.
That very much so, and that's why I kept on saying, there are more provisions in here than just raising the amount or having a statewide bond schedule that are going to be beneficial to bail agents. And I've said this. I said this on our last podcast. I mean, I have, and again, this was a bill that we supported, but we did push. The bail agents in Florida, as long as I've had them, have never said, "Hey, let's institute this policy or this law." So people, it's harder for them to get out of the jail and they have to get bail. No, that we've never done that. What the legislature has done, and the governor did here, is saw policy that made sense, and that's what you saw implemented.
Well, and I know that this bill was signed on May the 1st by Governor DeSantis, and it goes into effect January 1, 2024.
Yes.
So just in a few months. And I saw some of the press afterwards. The author of the representative carrying the bill, Paul Renner. Is it Renner?
Well, Renner is our speaker. The one you're talking about.
Oh, you're right. Yeah, you're right.
Yep.
I was. So,
but you're good. And the other one was Garrison.
But he touted a whole bunch of positives, and that this was one of the highlights of this legislative session. Governor DeSantis has issued a press release talking about how great this bill was, and I think even the Federalist did a article where it had an opinion piece saying that 1627 would strengthen Florida's bail laws and protect Floridians from bail reforms favored by soft on crime leftist prosecutors. And so, Florida's kind of following the path of Texas in rejecting soft on crime bail reform and strengthening bail reform. Because I mean, some of the crimes that you're not eligible for a bond pursuant to the uniform bail schedule is initiating a riot and stuff like that.
Correct.
So they were taking a strong stand kind of against these soft on crime policies that we're seeing.
Yeah, so that was the initiation. I didn't mention that earlier, but the governor did put in last year into law. So anybody that, all these rioters, if you're rioting, you do not get bail. I mean, so we had some expectation that, he was trying to be a little bit harder on crime with that statement last year with all the riots going on around the nation. And so this was his, second step.
So what do you think the impact of 1627 will be?
I honestly think, first of all, obviously it's going to prevent a person from being released, prior to the first appearance. You're going to see less pretrial programs, folks on it. And, you're going to see people that are going to be held responsible by bail agents and get them to court and on the provisions that they have on their bond. I really do. I mean, I was confident of this. Now, again, I was telling our association, trust me, but I was confident that these provisions would happen. We'll see. But, right now it wasn't going down a good path. We saw what was happening in Miami. And if Miami got away with it, Palm Beach was going to go next. Another of our, high population Democrat run counties, we would have seen it. So that was just the natural next step anyways.
Well, I would argue that it also is going to add consistency throughout the state and uniformity. And so that's going to build confidence in the criminal justice system because people are going to be treated the same no matter which county. So you're not going to see Dade County or Miami-Dade County doing what they were doing. That will change, which I think is probably the one of the goals of the bill. And I think that's a positive. I think that's a positive thing. I mean, there's been articles recently talking about we're just kind of turning over our inner cities to organized crime, or, that's the impact or the effect of what we're doing. And, I just can't get my head about why would we do that? Why would we do that? And, you could make an argument that they just want to create chaos. They want to decriminalize things. And you could see that you could also argue that it's some type of wealth redistribution. And maybe it's all of those things, depending on who you're talking to. But I mean, it just didn't make sense when you're allowing policies that's going to decrease your property tax base. So you have less taxes, you have less money to provide services, you have businesses closing. So the mom and pops that are retired are going to have to drive or travel longer distances just to get prescriptions. I mean, I just can't imagine why I would never do that for my parents. Why would anybody do that? But we seem to be doing it and seeing it across the country in our urban areas. And I don't see that. And I don't know how it will continue because it's not sustainable.
It's not at all.
Well, and I was thinking that, this is kind of probably going to sound crazy, but at one point in time, our criminal laws were meant to protect the criminals from the lynch mob, the posse. So
Right.
but it seems like, I had a prosecutor when I first came to Tyler, Texas, and he was very conservative, but he was very strongly supported by, reelected by strong majorities. And the reason why is, I was told he was colorblind when it came to crime. He prosecuted minorities just as much as he did non-minorities. And so they appreciated that he didn't discount crime because it was dealing with a minority. And we seem to be going back in our urban areas where we're discounting crime. And most of the inner cities are our minorities now. And that seems to be a step backwards. And the result will be we will have justice and we will have vigilante justice. And we can't, that's why I say it's not sustainable. So it can't continue. Yeah. And we have to figure out a way to get past this point in time.
I agree.
Well, talk to me about other bills that passed this session for the bail industry.
I'll talk about one that we killed. This was really a big bill that, that's right, we had talked about before. It was actually the author of a charity bill, the past two sessions, Representative Alex Andrade. He saw that anything with charity bail was not going to pass in the state of Florida, not now, not in the next 8 years. We'll say again, you'd have to see a huge turnover. So what he did was he created a bill that he called withholding funds for the return to cash bonds. What he did not like is I go to court, I get a DUI, and the judge says, I know you have your $500 that you have there for your bond. You had a cash bond. I'm going to take the fines, fees, and court costs and take your bond. Have a nice day, Mr. Foster. So what he didn't like is that he wants it to continue. If he felt that if it was grandma or anybody else besides the husband and the spouse, that they should all get their money back. And I can see his side. I do understand, grandma puts it, but you know what? Grandma also signs. It is well printed. That's the biggest print on the bottom. And it says, this could be applied to fines, court costs, and fees. What we argued is, number one, I believe this was just this bill, I forgot to tell you this part at the beginning. This bill was he actually changed the bill last year. This bill was actually charity bill last year. He did a strike all amendment. So a strike all, as you know, is it takes everything that was in there and it puts in new language. So he took out his intent to have charity bail and then put in this language. So what his intent is to have some executive director of the bail project bailing out 100 people, whatever. It doesn't matter. There was no limit to how many people I could bail out. And as long as they get the court, I get all my fines, fees, and court costs. Well, you're basically now an unregulated, unlicensed bail agent in the state of Florida. So that's what we stood up. Now, there was some other secondary impact we're trying to explain to him. Number one secondary is the fines, fees, and court costs went to the Domestic Violence Trust Fund, the Traumatic Brain Injury Trust Fund. I mean, very, I'm just giving you some of the two top names that came to the top of my head, but I'm telling you, like, very important things that we try to help here in the state of Florida when somebody gets arrested and we put in these trust funds. And then lastly, the number one reason that people were having violation of probation in the state of Florida, because they didn't pay their fines, fees, and court costs in the time. Because what happens in Florida, if you don't do it within 30 days, you leave that court and the judge says, pay this, you have your license suspended. And the number one reason the people have a violation of probation is a suspended driver's license because they didn't pay their fines, fees, and court costs. And now we've just made this worse. As you know, you go now, they get arrested, they can't get bail. And we just made this that much worse. So we've defeated this now 2 years in a row. He changed it last year. He brought it back broadly as this bill. He told me this year, my friend, he says, I'm coming after you. You killed it last year. You won't be able to do it again. I mean, that was his quote. He says, I have a state senator now who is a an attorney also, and she's not going to let this bill go. Well, we defeated it on both ends. It got through only one committee in the Senate, two committees in the House, and it was defeated and didn't go anywhere after that. But it's coming back.
The problem with the charitable bail is more and more information is coming out. And, what we're finding is they're not bailing out first time offenders. They're bailing out the worst of the worst people that are
Right.
stuck in jail. And honestly, they need to stay in jail. And so we should not be state sanctioning, these charitable groups bailing out the worst of the worst and there are a lot of times they're career criminals. So they're just bailing them out so they can commit more crime in the name of social justice. And I think that it's reasonable, like Indiana did, by placing a limit on the size of the bonds they can post. And I think it's reasonable for, Florida to say, hey, we're not going to allow you in our state. So I think that's all great. Now, I know there's some technical changes that were made about how the bail industry conducts business. One of them was like for a temporary license. Can you talk about that?
It is. So this was HB 487, and I just want to really speak two parts of this. One is the relationship with the sponsor of the bill. I have a bail agent in her district that goes to her fundraisers, meets with her at the office. It's actually Carrie Carlisle, who is our legislative affairs director. We've been involved in her campaign and supported her. But number one, this was called DFS bill, Department of Financial Services. We have made it a priority to be very close to our CFO, who regulates. Sorry about that. I was trying to tell me I've got a low battery coming up. And that regulates bail in the state of Florida is our CFO. Well, we have made it a priority to get to know him, invite him to our conferences, have done several fundraisers for him. And he wanted to put in, there was a lot more in here. So there, he regulates, he was very careful. It's like, I can put things in here that we regulate, but not the part of the policy over bail. Like, I regulate bail agents. The purview of actual other policy matters and everything that we just talked about in 1627 are not under the purview of the CFO, right? So we had to change it. So real quickly, we had previously a 24-month, basically an internship. It was called a temporary license. This person could not write bail. So on average, they were making $15 an hour. Who's going to get into truly in the bail industry? And you're going to get a qualified, you're going to get a trained bail agent with that? No, this is something that really we needed to do for many, many years. Now you take the test, you become a licensed agent. You can work under a bail agent for 24 months. You can collect bail. And after that 24 months, you become what we call a primary agent. And you can start your own business. It was much, much better than it was before. And it should have been changed years ago. The only other qualification that we changed in there too is a training component. We had in there currently that all trainings for CUUs and getting your license had to be in person. Well, we all know that Zoom that we're doing right now worked really well during COVID, and it works really well now. So we put in there also virtual formats like Zoom that folks can get their trainings.
And how is that going to work? Is the association still doing the training?
So we're not the only ones doing the training. There are other folks that are doing the training. I would like to say that we were the only ones doing the training. We would love to put it in that. I can't put that in law yet, but we are putting together programs to enhance our capabilities through it, meaning through CEUs. Association is coming up with a new curriculum we're going to have the department look at and support.
In Texas, we have a requirement that you have to do it in person as well. And, the big reason why we haven't moved to change it is because just like Florida, historically, we're not the only ones that do schools. We're the only one currently, but then it's what would happen if we made it virtual, and how, because that's a large part of the income of the association.
Right.
And so
it is.
I don't know.
And well, the only part that is unfortunate, I shouldn't say, is that we are one of the only industries regulated by DFS that is limited to in person right now. They have wanted, and the governor has wanted that. He has wanted to remove unnecessary regulations, and he feels that in this time and age. So we felt that this was a good compromise. So it didn't die.
So how do y'all plan on changing and reacting to that amendment?
Well, I mean, it actually still works well because we've been utilizing. We're able to continue to utilize Zoom for it. So I think it's going to work well for us and for,
Okay.
say it's competition. The virtual format is still live. So,
Okay. Okay.
right.
Right.
I'm
They
sorry.
they can attend in person or virtually.
Right. I didn't clarify that. Yeah. So when I meant Zoom or web, any other way, it can't be recorded. It has to be live. So that still takes
Uh,
that live class in context.
Good idea. Good idea.
But we did not want to go to full recorded trainings and so forth. We
Mhm.
felt the live Zoom was, and it's also, let's be honest, right? We're doing this, through Zoom. People could be in Orlando instead of Miami, and maybe we could even do more money that way because somebody doesn't want to drive to Miami or to other area. They want to sit there right in front of their computer and take the class. And
Okay.
honestly, if we didn't do it, Ken, it was
Yeah.
going to be
Yeah.
taken out of our hands. We felt it was a good compromise with the CFO to offer
No,
it.
I agree. I think the way y'all changed it, it's a great compromise because it really indirectly still gives you control over your continuing education.
Correct.
Even if you're not the only source, but you still have your revenue coming from that. In Texas, when the legislative session's over, we give an after action report and we'll speak at our annual meeting in October. The governor has had 2 or 3 special sessions. He's going to have more. We're fixing to have a impeachment trial for the attorney general starting in, the September 7th. They can start filing pretrial motions out at around August the 5th. So we're fixed to be all consumed with impeachment trial in the Senate. And then in October, which is the next special session, the governor vetoed 60 to 80 bills because he wanted to focus the legislature on property tax reform. He's now gotten that. So, and he has said bail reform will be on a special session. So I'm expecting bail
Yes.
reform once again to be on the special session, probably during the same month as our annual meeting. So it's going to be high stress and crazy. But what do you tell your membership? What's the lessons learned from this session, and what's the takeaway from this session in Florida?
So the lessons takeaways really is relationships and networking.
Mhm.
I could not emphasize more to them about going back to their district. And I wouldn't embarrass anybody, but I almost wanted to say, how many people in this room don't know there's actual state rep and state senator? If you don't, bad on you. Go do it. Because the relationships that we have culminated over the last couple of years have driven the message. It really did. And I would say the relationships, networking, getting to know your legislators, and fundraising. And fundraising has been such a huge component. Our folks now are invited to events with the House and the Senate
Mhm.
majorities. I told you about the CFO. We actually helped sponsor the chief financial officer's inauguration luncheon.
Wow.
It was one of those we wanted to be out there. So I think if anything, that message was stay involved, get to know your legislators, help us fundraise, and just know that Charity Bill and these other ones will have to continue to fight next year like we've done every year.
Well, we've had a member of our association who's a good friend. But he's, at a meeting, he just stood up and said, "Why do we fight every 2 years? Because our sessions just once every 2 years. Why can't we just fix this? I mean, why can't y'all just fix this?" And I'm like, because we're fighting. They disagree with us, and we're going to have a disagreement every 2 years. And so I mean, there's not a fix. The fix is giving up if you really want to
Right.
quit fighting, or we continue fighting. But what I tell people is also what's good for the criminal justice system is usually good for the bail industry because we are so intertwined. The reason why we're so intertwined is because we have the lowest failure to appear rate. We've been around for 200 years because of that. And until they can come up with something that's anywhere near comparable, we will continue to be operating because nothing else is even close.
I agree.
Well, thank you so much for talking with me. So sorry that I thought today was Wednesday, but I've been looking at this stuff about the Florida legislative session, and it was so much more than what I was expecting.
Well, just so you know, we usually have a rule: if somebody is late to the meeting, they have to buy the next lunch. So you'll have to buy the next lunch together. Okay.
All right. Well, good. It's good talking to you, and I will see you around.
Thanks again for inviting me. Have a great day.
Okay. Bye.
Thank you for listening, and come back for the next episode of The Bell Post.